Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 16th lecture. In this lecture, I would like to highlight prison reform and human rights. So, in this lecture, we will try to understand how prison reform is directly connected with human rights. Is there any connection between prison reform and human rights? And what are those human rights which prisoner can avail, which prisoners are entitled to get from the prison authority? And firstly, we will try to understand what are those human rights which are directly connected with prison and why prison needs to be reformed. So, we will try to understand the connection between prison reform and human rights. So, let us understand this human rights and prison reform. So, with the help of this slide, I would like to discuss prison reform. You see why prison reforms? Prison Act 1894, you can see the year of this statute. This statute was enacted in 1894 and Supreme Court has already highlighted the need to amend this Prison Act, in this case Ramurthy versus State of Karnataka. In this case, Supreme Court for the first time emphasized that now time has come that century old prison need to be amended. You see, even Supreme Court has already highlighted the need and problems which Indian prison system is facing right now. So, Supreme Court said that century old prison act needs to be amended, because this statute is not adequate in addressing all the needs, all the grievances of prisoners. So, that is why this century old prison act should be amended, should be reformed. Why prison reform is needed? You see, in this slide I have highlighted different areas or challenges which Indian prison system is facing right now. So, the first problem which Indian prisons are facing, that is overcrowding in prison, lack of staff, trained staff, nexus between criminals and prison staff. This is the third problem which Indian prison system is facing. Proper food, sanitation in prison. So, you see, these things have been identified by prison committees. Different committees on prison reform have highlighted that Indian prison system is facing overcrowding problem. Capacity of Indian prison is a big issue, big challenge. Untrained staff, means we do not have trained staff, we do not have technical support. So, nexus between criminals and prison staff, that is another important area where it needs to be amended, it needs to be reformed. Many times you might have seen that criminals, habitual offenders who are in jail, they can easily manage all the means, all the modern techniques which they can use outside the prison with the help of prison staff, and they can use, many times they are found using mobile phone in prison. Mobile phones are prohibited in prison, but in spite of that you might have seen that media reports reveal, newspaper reports reveals that criminals are using mobile phone, cell phone in prison. So, they are well equipped in even prison. So, this is because of nexus between criminals and prison staff. So, due to bribe or due to other considerations, prison staff they provide mobile phone and other means to the criminals in prison. So, this thing has been identified by committee. Proper food and sanitation, prisons, Indian prison system is also there is no proper hygiene or proper sanitation in prison. So, these are important things which needs to be addressed by our prison system. Overcrowding, lack of staff, nexus between criminals. You see, you all might be aware about Amulla Committee on Prison Reform 1980. Government of India, considering the gravity of prison reform, constituted a committee under the chairmanship of A.N. Mullah, and Mullah was the chairman of that committee. That committee recommended that political offender must be separated from convicted offenders. There is clear cut provision in Prison Act that political offenders must be kept separately in prison. They cannot be kept along with convicted prisoners. Under trial prisoners and convicted prisoners, so there must be separation between convicted prisoners and under trial prisoners, because convicted prisoners are offender in eye of law. Convicted prisoners, they have committed offence in eye of law. So, that is why judiciary has convicted them. If convicted prisoners and under trial prisoners both are kept together, there may be chances, there may be possibility that under trial prisoner may also become habitual offender if they are kept along with convicted prisoners. So, there is always possibility to repent for those under trial prisoners. If under trial prisoners are kept separately, they are not guilty in eye of law because matter is still pending. So, unless their offence is proved before the court of law, they are innocent, they are under trial prisoners, they are waiting for their trial. So, they should not be kept along with convicted prisoners, and if they are kept separately, there would be chances for their rehabilitation, for their reformation. They can be kept into the mainstream of the society, they can be bring back in this mainstream of the society. Otherwise, if they are kept along with habitual offenders, convicted offenders, there would be little chance, little possibility to bring back in their mainstream of the society. They might become habitual offender if they are kept along with convicted prisoners, habitual offender. So, this committee has highlighted that there should be clear cut separation between convicted offenders and under trial prisoners. Third important suggestion which this committee has made, that public and media visit should be allowed for transparency in jail. So, this committee has highlighted that media should be allowed to visit the jail, to visit the prison, or public should also be allowed. If media personnel, if media people are allowed to visit jail, then jail authorities would be vibrant, would be aware that any time media personnel, media official they may come and they may raise, they may blow the whistle, they may raise objection, and they may expose the things which is going on this in a particular prison. So, to my knowledge, and this committee has also recommended that the role of media should be promoted, and media personnel should be allowed to take interview to the prisoners or to expose the things which is happening inside the prison. Another important committee, Justice Amita Rao committee report has also given some important suggestion for prison reform. Mullah committee, you see, has also recommended that there should be adequate provision for clothing, sanitation and food. Speedy disposal of cases by fast track. Fast track should be signed, should be entrusted the cases so that pendency of criminal case can be reduced. Prison infrastructure, Prison infrastructure should also be enhanced. Accommodation and resources for prisoners should be provided by the government. All these things can be done with the help of government, and government should provide infrastructure to the government. You might have seen that our prison system are facing problem of computerization in this digital era. Study reveals that most of the prison in this country, they do not have computer, they do not have internet connection, and particularly prisons which are in remote areas, they do not have proper connection, proper connectivity, internet connectivity, and due to that they are not aware about the government schemes, government initiatives or judiciary initiatives. So, unless we provide basic amenities or infrastructure to the prison authorities, prison system would not be effective. So, these are some valuable suggestions, recommendation of this Mullah committee. And you see, apart from this, let us understand that what are those human rights, how this overcrowding in prison is affecting human rights of the prisoners. As you all might be aware about, health is important issue, and right to health, that is a fundamental right, that is essential component of Article 21 of the Indian Constitution. And in case of overcrowding, where prisoners are kept in prison beyond its capacity, so it would be very dangerous, it would be very harmful for the prisoners, and they may also suffer so many venereal disease, infectious disease or chronic disease due to sanitation problem, due to overcrowding. So, this right to, since Supreme Court has already recognized right to health as important right under Article 20 of the Indian Constitution, and this right to life would be meaningless unless this right to health is not connected with, is not recognized under Article 21 of the Indian Constitution. So, and Prison Act 1894 specifically talks about that it is legal obligation of jail authority to provide medical facility to that prisoner who is suffering from medical problem. So, medical assistance is statutory obligation, and prison authority, jail authority has to provide medical assistance to the prisoner. So, this right to medical aid, and if suppose if jail authorities and working staff, employees working in prison, they are not trained, they do not have any idea about the problems, they do not have any idea about statute, prison act, they do not have any idea about health issues. So, it would be very difficult for jail authority to provide medical assistance to the prisoner. So, this is an important issue which we are facing right now, which Indian prison is facing right now, that due to untrained staff in prison, many prisoners are facing either psychological problem or health problems, mental disease, acute disease, chronic disease. And if you might be knowing that each and every jail has its own hospital. In that government hospital, government doctors, they have to provide medical assistance to the prisoners who are suffering from medical problem. So, unless we have trained staff in prison, jail authorities would not be in position to provide medical assistance to the prisoners. In this way, if employees or prison staff are trained, if they are provided good training about health problems, about disease, then it would be very easy for jail authority to protect right to health it would be very easy for jail authority to protect human rights of the prisoners. Right to safety is another important concern. Right to safety is important right. Many times we have seen that prisoners are killed in prison or either by inmates of the prison or even state. Sometimes jail authorities are involved due to means cases pertaining to custodial violence, custodial death even in prison are reported by media or by press. So, due to media report or we become aware that things are not going good in prison. So, right to safety is another important issue, and right to legal aid. Many times we have seen that prisoners who are poor, who are not in position to engage their counsel in the court of law, they are deprived and they have to languish in jail for longer period. So, all these things have been identified by judiciary, as I have already highlighted in my previous lecture. Right to legal aid, right to free legal aid, how these human rights are connected with prison reform. If prison staffs are well trained, then it would be very easy for prison authority to provide, to engage counsel, legal representation, medical facility, right to food. This Prison Act 1894 specifically talks about imposes obligation upon jail authorities to provide food to prisoners. So, this is statutory right, right to food, sanitation, right to fair wages. You see, where jail authority has engaged any prisoner, jail authority has engaged prisoners in any activity, and prisoners are also particularly under trial prisoners are entitled to get fair wages. If they are compelled, if prisoners are compelled by jail authorities to render their services, they are not paid, it would be violation of their rights, it would be violation of their fundamental rights. You all might be knowing that Article 23 of the Indian Constitution talks about beggar, forced labor, and where prisoners are forced to perform, to do any business, to do any activity in prison, and if they are not paid by jail authority, it would be violation of their fundamental right guaranteed under Article 23 of the Indian Constitution. It would be considered as beggar, involuntary work without payment, and that prisoner may challenge the order of the jail authority wherein prisoners were compelled to do any work against their desire, against their will. So, Supreme Court has already highlighted that right to fair wages is fundamental right, right to fair wages is human right, and that is why jail authority is bound to ensure fair wages to the prisoners. And in Supreme Court in Gayasuddin versus State of Andhra Pradesh has categorically held that even prisoners are entitled to get fair wages. Where jail authority has failed to provide fair wages, it would be violation of fundamental right, and state concerned, authority concerned may be held responsible for that. So, this is another important right, right to fair wages. How overcrowding this prison reform, as I have already highlighted one important issue which Indian prison system is facing right now, that is overcrowding. So, how overcrowding can be avoided? Can be either we can construct new buildings, we can improve our infrastructures. That is not easily possible, it will take time to enhance the capacity of prison. But on the other hand, if we adopt the policy of Malimath Committee constituted by Government of India, and Malimath Committee has given its recommendation in 2003, Malimath Committee on Criminal Law Reform. I would like to refer the recommendation of Malimath Committee. Malimath Committee has recommended that criminal court should release the offender where offender has committed offence which is punishable with less than 7 years imprisonment. So, by doing so, we can reduce the burden, unnecessary burden of prison, jail, where under trial prisoners are facing their are waiting for their trial, and they have come, the allegation against them are those offences which are less than 7 years imprisonment. Supreme Court has already held that in Supreme Court in Moti Ram versus State of Madhya Pradesh, CIR 1978 Supreme Court. In this case, Supreme Court has already held that bail not jail. Bail should be a policy. Bail, more and more offenders should be released on bail, and if suspect under trial prisoners are released on bail, it would mitigate the problem of overcrowding. So, because you might have seen that in most of the cases, offenders, prisoners who are languishing in jail have committed crime, have committed petty offences or offences which are punishable with less than 7 years imprisonment. And this offence is not so serious. So, Malimat committee has recommended that those prisoners who have committed offence which is less punishable with less than 7 years imprisonment, they should be released on bail. If bail is granted to them, it will serve two purposes. The first purpose is it will reduce the burden of Indian prison. Secondly, it will reduce unproductive expenses of government. You see how where prisoners are kept in prison, and those prisoners have committed offence which is less than 7 years imprisonment. It is the legal duty of government to provide food to the prisoners, additional expenses. At the time of trial, they will have to produce before the court. So, from prison, from jail to court, vehicle facility is provided by the government. Police escort is also provided by the government to the offenders. And even if an examination of witnesses, cross examination, re-examination of witnesses, it takes time, and government has to provide food, government has to manage police escort, government has to manage vehicle for those offenders. So, if we follow this suggestion, if we adopt this suggestion, so by adopting this suggestion, we can reduce pendency of criminal cases, as well as we can also reduce unproductive expenses of the government on the criminals who have committed petty offences. Also, in this way, the first problem which Indian prison is facing right now, overcrowding, can be handled, can be tackled in effective manner. To overcome this first problem, we can adopt this policy that bail not jail, and more accused, more and more prisoners should be released on bail who have committed offences which are not punishable with more than 7 years imprisonment. So, this is one important suggestion which needs to be taken care of, which needs to be incorporated. And Supreme Court has, in Arnesh Kumar versus State of Bihar, AIR 2014 Supreme Court, Honorable Supreme Court has already held that no arrest shall be made in those offences which are punishable with less than 7 years imprisonment, unless there is possibility that accused will not cooperate in investigation, accused will not cooperate the police. In exceptional circumstances, arrest should be done. Otherwise, rule is that no arrest shall be made in the offence which is punishable with less than 7 years imprisonment. So, overcrowding is a problem, and if authority follow this guideline issued by Supreme Court, so we will reduce the pendency of criminal cases, as well as we can reduce overcrowding in prison, overcrowding from the jail. how this prison reform can be, by what means, by what method we can reform our prison system. This is the first suggestion. Second important suggestion is by which we can make our prison system more effective, that is awareness, education. Aware means employees working in prison jail. So, prison staff should be trained from time to time, and jail authority should ensure that all the employees working in jail must be equipped with statutory provisions, must be trained, must be educated about human rights. Human rights education must be provided to all the staffs, to all the employees working in prison. At least prison staff must be taught human right education, human rights, what are those human rights which are available to the prisoners. So, by doing this, prison staff may be vibrant, may be aware that if they will not do this thing, then the human right of the prisoner would be violated, and they can challenge the order of the jail authority. They can prosecute the jail authority or any employee of the prison. So, that is why it is necessary that jail staff must be trained, must be taught human rights duties to, so that they cannot violate the human rights of prisoners. This is another important area where the third important suggestion is by promoting, by inviting NGOs, non-governmental organization. NGO can play important role in protecting human rights of the prisoners. How NGO can play important role in protection of human rights of the prisoners? You see, non-governmental organization, NGO, which are working for the protection of human rights, there are so many NGOs working for the protection of human rights. You see, they can access to the prison, they can go to the prison and they can talk to the prisoners one by one, and after having information from the prisoners, that NGO may provide that NGO may provide literature to the prisoners that this is your rights. Many prisoners, you see, they do not have any idea about their rights. What are the rights available to the prisoners? Whether they have right to get legal aid, they have right to get medical aid, they have right to get food from the authority. They do not have any idea about their rights. So, to make them aware about their rights, NGO can play important role, and in this way you might have seen that IGNO few years back, IGNO started a program for prisoners. Indira Gandhi National Open University, IGNO started a scheme to teach, to make them aware, to teach the prisoners, and formulated syllabus as per their requirement, so that prisoners who are not aware about their rights, they can be made aware about the rights as well as if they want to learn more from IGNO. So, IGNO played important role in formulating their syllabus and conducting examinations, providing study material to in prison. So, in you see, NGO can also play important role to improve this prison system. This is the third important. Media can play important role for the protection of human rights. For example, you see, media personnel, if they are allowed to take interview from prisoners, that whether they are getting proper treatment from the jail authorities. So, on the basis of interview method, which media may conduct, which media may be invited, the things which is going on inside of the prison maybe can be carried out by the media personnel to outside the prison. So, it would be very easy for jail authority to take supervision and as well as vigilance over their staff. Many times jail authorities they are not aware about the things which their staff, their employees are doing in the jail, in the prison. So, media can highlight, media can expose the bad things which is going on in the prison. So, in this way we can also, so this prison reform and human rights, these two things are directly connected. As I have already highlighted that in Sunil Batra case, Sunil Batra being a convict wrote a letter to a judge of Supreme Court and his letter was accepted as a petition, and in that case Supreme Court constituted a committee and all the allegations were found true, and on the basis of that letter, content of letter, Supreme Court took cognizance and Supreme Court issued notice to the Delhi administration that jail authorities, Tihar jail authority had committed violence against that or had failed to protect the rights of inmates of the prison, and in this way Supreme Court for the first time held that right against inhuman treatment, that is fundamental right, essential component of Article 21 of the Indian Constitution. I have already highlighted one important leading case of Hussain Ara Khatun versus State of Bihar, where a female offender Hussain Ara Khatun, she was languishing in jail for a longer period, and her plight was brought into the notice by Kapila Hingorani. So, and in that case Supreme Court held that right to free legal aid is a fundamental right, this should be provided by the government. Now, come to this slide, I have highlighted that by what means, by what method we can reform prison system, how to reform prison system. So, I have chosen this case Moti Ram versus State of MP, bail not jail, speedy disposal of cases. First is legal literacy camp in prison. Second is prison staff by providing in first. Third is, you see, there is also an effective method to reform the prison system, that is legal literacy camp in prison. So, if we organize legal literacy camp in prison, if government takes this initiative and organize legal literacy camp in prison to make prisoners aware about their rights, it would be a milestone in recognizing, in achieving the objectives enshrined in our constitution. So, it would be very good, it would be a very great achievement if legal literacy camp is organized in each and every jail of this country. So, by organizing legal literacy camp in jail, jail authorities can educate them, can educate the prisoners about their rights, what are the fundamental rights, what are the human rights which are available to the prisoners, under trial prisoners, convicted prisoners. So, legal literacy camp is very necessary because Supreme Court has already held that every arrested person has right to consult from his counsel right from the arrest until the completion of the trial. At the moment a person is arrested by arresting officer, at that very moment the arrested person may ask the investigating agency that without consulting his counsel, he will not speak, he will not give any evidence to the investigating officer. So, you see, in this situation, if arrested person is provided counsel by, is given opportunity to consult from his counsel advocate, that in the presence of his counsel his investigation must be completed, and because there might be a problem for that arrested person. Police may commit any torture or atrocity against that arrested person. So, Supreme Court has already held that arrested person can demand from the investigating agency that investigating agency should, arresting officer should wait till the advocate or his counsel join that investigation. So, after that investigating officer, investigating team can start the investigation. So, these are the safeguards, these are the protections provided to the arrested person, to the prisoners. Even prisoner may ask the authority concerned that he must be represented by his counsel. Legal representation is a fundamental right. Legal representation is a statutory right in criminal case provided in section 303 CRPC. Section 303 CRPC specifically talks about legal representation in criminal case. Every criminal, every prisoner has right to get legal assistance from his advocate. Every section 304 CRPC talks about free legal aid in criminal case. Every arrested person, every prisoner has right to get legal aid, legal assistance free of cost if he is having BPL card, if he is below poverty line and has committed any crime. So, that prisoner who is poor can get legal aid free of cost under section 304 of the CRPC. Article 22 is also there, is also helping the criminals, and so suspect innocent persons, so they can take shelter from Article 22 of the Indian Constitution. So, this is all about your prison reform, legal literacy, paralegal services, NGO, role of NGO. So, this is now role of NGO. I have already highlighted role of NGO in prison. I just want to throw some light on this role of NGO in prison reform. For under trial prisoners as well as convicted prisoners, financial assistance and their involvement in making soap and carpet and clothes. So, you see, Tihar jail is considered as model prison in India, and when Kiran Bedi was, she is a very dynamic personality in Indian police services, and she was the first IPS officer, female IPS officer who took responsibility. He took a great initiative to reform prison system, Indian prison system, and because of her contribution, Tihar jail is considered as model prison for this country. So, you see, Kiran Bedi, she started a program in Tihar jail and with the help of NGO, so that the poor accused, the poor prisoners who had some problem, financial problem, they could be provided financial assistance with the help of NGO. So, they were involved in making soaps, carpet and clothes inside the jail, and NGO was allowed to take their product in the market, and this is another method to provide financial assistance to the poor prisoners. Now, this is all about your role of NGO in prison system, protection of prisoners right through prison reform. You see, this right to food, I have already highlighted this, sanitation and hygiene in order to prevent them from infectious disease, right to medical aid by establishing better hospital, and now you see, just protection of prisoners right through prison reform, right to medical aid by establishing better hospital. So, this is also, this is a policy matter, and by establishing hospital or by enhancing hospital facility, we can enhance our medical facility in hospitals. And you might, many times you might have seen that prisoners, they need psychotherapy, psychologist assistance, and there is a clear cut provision in statute. Committee on Prison Reform has also recommended psychiatric doctors should be provided to the prisoners who are facing mental problems, and it is the duty of jail authority to conduct a medical camp in jail, so that prisoners they can give entire information about their sickness, medical problem to the jail authorities and to the doctors. So, periodically jail authority should organize medical camp in the jail in order to provide medical assistance to the prisoners. This is another important area where state intervention is necessary. State should come forward to protect the rights of prisoners. Right to food I have already highlighted. Now, next thing is that right to free legal aid, prisoners' right to free legal aid, right to speedy trial, as I have already highlighted these two important components in Hussain Ara Khatun versus State of Bihar, M.H. Hoscott versus State of Maharashtra. As per Krishna Iyer Committee on Prison Reforms to improve women prisoners, this committee was set up by government to give valuable suggestions, so that female offenders can be put in better position, or their position may be female offenders, they may be rehabilitated. So, this is another important committee, Krishna Iyer Committee on Prison Reform. Now, you see, Supreme Court has already issued various guidelines for the protection of rights of the inmates of prison. Veena Sethi versus State of Bihar, this is leading case on rights of inmates of the prison. Veena Sethi versus State of Bihar, AIR 1983 Supreme Court. In that case, what happened? Hazaribagh is a district in Bihar. So, in that case, Veena Sethi, she had gathered information from different jail of Bihar, and by that report she tried to highlight the plight of inmates of the prisoner. And in this Veena Sethi case, Supreme Court held that it is constitutional obligation of state to provide free legal aid to poor prisoners who were not in position to engage their counsel. So, Veena case you can also refer Veena Sethi case in this head. Another important case on this point is Sheela Barse versus State of Maharashtra. In Sheela Barse case, Sheela Barse, she had highlighted the problems of female offenders against whom torture, assault and sexual assault, they had been sexually assaulted. So, Sheela Barse, she also filed a petition in Supreme Court by highlighting the plight of female offenders in prison, and Supreme Court issued guidelines in even in that case. So, Sheela Barse case is leading case on prisoners' right and prison reform. So, these are leading cases on prison reform and human rights. Prem Shankar Shukla versus State of versus Delhi administration, I have already highlighted. Prem Shankar Shukla, protection against handcuffing, protection of no prisoners shall be kept on bar feeders. Charles Sobraj versus Delhi administration. Supreme Court in Prem Shankar Shukla versus Delhi administration, Supreme Court held that no prisoner shall be kept on bar feeders, shall be put on bar feeders unless there is possibility that he might abscond from the prison. Sunil Batra case is important from two point of views. First, I have already highlighted that in Sunil Batra case, Supreme Court for the first time held that protection against inhuman treatment, that is essential component of fair trial. Article 21, right to life, and right against inhuman treatment, that is human right guaranteed in Universal Declaration of Human Rights. The second important observation of Sunil Batra case is that in that case, Sunil Batra had challenged the legality of section 58 of the Prison Act 1894. In that Prison Act 1894, there is a provision that jail authority, jail superintendent, no superintendent jail shall put any prisoner on bar feeders unless the information, unless the ground is disclosed, unless the ground is informed to the prisoner. Without informing the ground, no jail superintendent shall put any prisoner on bar feeders. So, that is you see directly opportunity of hearing is given, principle of natural justice is given in Prison Act 1894, that no prisoner shall be put on bar feeders or in iron bars. So, that is prohibited. If there is possibility that prisoner might abscond from the prison, he is habitual offender, then in that case it shall be lawful for the jail superintendent to put any prisoner on bar feeders. But without giving information, without communication, without informing the prisoner, jail authority cannot put him on bar feeders. It would be violation of his statutory right as well as violation of fundamental right. So, Supreme Court declared that provision unconstitutional because authority is obliged to follow the procedure prescribed in Prison Act 1894, that there must be cogent reason for putting any prisoner on bar feeders or any. So, that is handcuffing. Cogent reason must be there. Without cogent reason, authority cannot take any decision. Authority will have to justify. So, this is another important area where prison reform and human rights can be taken together, and you all need to understand that human rights, and then you can understand the prison reform. And another important thing which is essential for prison reform as well as the human rights of prisoners. You see, you might be aware about prisoners, under trial prisoners and convicted prisoners, juveniles also. There is separate provision for juvenile offenders. Juvenile who is conflict with law means a child who has breached the law and below 16 years, that child cannot be kept along with habitual offender. So, there is separate provision for juveniles. So, every district has its own juvenile district reformatory homes, district juvenile homes. So, the purpose behind establishing separate juvenile district juvenile homes is to rehabilitate, is provide an opportunity to the juveniles so that they can repent themselves, so that they can be brought into the mainstream of the society. So, that is why there is separate provision for juvenile offenders in India. And you see, PIL, public interest litigation, has become important tool in protection of human rights of the prisoners. You see, many times you might have seen that through PIL, the plight of prisoners has been brought into the notice of High Court or Supreme Court. So, PIL has also played important role in protection of human rights of the prisoners. And as I have already highlighted, that Khatri versus State of Bihar case is one of them, and Sunil Batra, I have referred Sunil Batra case, Khatri versus State of Bihar, Sheela Barse case, Veena Sethi versus State of Bihar case. I have highlighted few important judicial pronouncement like Khatri versus State of Bihar, M.H. Hoscott versus State of Maharashtra, Hussain Ara Khatun versus State of Bihar, Veena Sethi versus State of Bihar, AIR 1983, Right to fair wages was recognized as an important right to the prisoners in Gayasuddin versus State of Rajasthan, Prem Shankar Shukla versus State of Delhi Administration, where Supreme Court for the first time held that right against handcuffing is a fundamental right, is essential component of right to life and personal liberty. Sunil Batra versus Delhi Administration, that is very leading case on Article 21 and human rights of the prisoners. This is important case on human rights of prisoners. And apart from this, I have also highlighted some statutory rights of the prisoners, like right to food, right to medical aid, right to uh, legal aid, right to free legal aid. These are right to life, right to safety. These are statutory as well as fundamental rights provided in Prison Act 1894 and the Constitution. As I have already highlighted that every arrested person has right to be produced within 24 hours from the time of arrest, Article 22. Every person has right to have a counsel under Article 22 of the Indian Constitution. Article 22 talks about legal representation, and 303 CRPC, 304 CRPC talks about a right to legal aid, right to free legal aid. So, I have referred constitutional provision. I have also referred statutory provision, the Prison Act 1894, so that you can get entire information regarding prison reform and human rights. So, I try to make relation, I try to connect prison reform and human rights, how prison reform is directly connected with human rights, because I have already I also highlighted the problems or challenges which Indian prison system is facing right now: overcrowding, untrained staff, atrocity, custodial violence inside the prison due to lack of awareness, poor infrastructure, sanitation and hygiene problem in prison. So, these are problems which Indian prison system is facing right now, and I also try to highlight some statutory provision or as well as judicial pronouncement and the role of different committees which have been set up by Government of India on prison reform. In that context, I have referred statutory provision, for example, section 27 of the Prison Act, section 17, separation of under trial prisoners from convicted prisoners. So, these are female offenders. It is the duty of jail authority to separate female offenders from male offenders. So, these are statutory rights provided to the inmates of the prison, and Constitution itself has guaranteed certain rights to the prisoners, to the arrested person, Article 20 clause 1, 20 clause 2 and 20 clause 3. I have already referred these protections, and Article 21, right to safety and right to life, right to live with human dignity. These are some important, these are few important fundamental rights as well as human rights guaranteed in UDHR 1948 and International Covenant on Civil and Political Rights. So, I think I have covered each and every aspect of human rights and prison reform, how by doing prison reform we can ensure the human rights of the prisoners, how we can enhance our prison system by digitalization, by providing computer or by providing more effective network in prison system, we can prevent custodial atrocity inside the prison. So, we have seen that you might have seen that I have covered each and every aspect of human rights of prisoners by highlighting constitutional provision, statutory provisions and role of Supreme Court in protection of human rights, and role of Mullah Committee on Prison Reform, role of Justice Amitav Rao Committee, Justice V. R. Krishnaiyer Committee on Prison on Female prisoners. So, I have already highlighted, and I do believe that you all have understood the things which I have just discussed in this lecture, and I have also tried to make this lecture more fruitful for you. If you read all these things, definitely you will get success in examination. So, with this I would like to conclude this lecture. Thank you all.
Hi, my name is Gillette Sam, and I teach sociology at IIT Kanpur. Today, I want to tell you a little bit about what sociology is. In order to go ahead and study sociology, one of the things you need to develop is a sociological way of thinking. Now, this capacity to think in a sociological manner was termed as the sociological imagination by an American sociologist called C. Wright Mills in 1959. He argued that in order to think in a sociological manner, you should be able to have two different skill sets. The first skill set would require you to have the capacity to think beyond the problems that individuals face. So, if you encounter a problem that some one individual is facing, you should be able to connect it to a broader public problem. Mills gave the example of people in his neighborhood. He says if there is one person who is unemployed in the neighborhood, that seems to be an individual problem. But as a sociologist, you're expected to dig around a little. So you come across a couple of other people in your neighborhood who are also unemployed. That indicates to you that rather than being a specific problem, there is a larger public issue at hand. So, as a sociologist, you're supposed to look at individual problems and see how they are connected to broader public issues. The second capacity that you're expected to develop as a sociologist is the capacity to link an individual's biography with history. Historical thought may not come to you as the first thing that's connected to sociology, but it plays a pretty important role in the field. So Mills argues that rather than looking at a problem in the here and now, it's important to trace that long historical trajectory that may be connected to this individual problem. Let me give you an example from India, right? Let's say you look at the women in your family. Let's see at what age do they get married. So you may see that your sibling is getting married at the age of 25. Go back one generation. At what age did your mother get married? You may find that she got married a little younger, let's say 21. Go back another generation. At what age did your grandmother get married? You may find that she got married even younger, 18 or possibly even younger than that. So this capacity to see how the history of a family then influences the age at which your sibling got married, that is the capacity to bridge the biography of a person, or rather by a biography we can also think of the biography of a particular problem with history. What has happened in the past? How is that connected to this individual or this problem in the present? Thank you.